You're in jail, this will get you out. If you're on your way to jail, this will stop it. If the IRS is on your ass, this will slam the door in their face. If CPS is trying to steal your kids, this will stop them cold. If a judge thinks he can railroad you without a verified claim, this will flip the script. This ain't legal advice, it's lawful warfare, and it's been working in silence for years. You want out? Then pick up a fucking pen. The notice from hell is about to be given to you. And as always, I do for you, you're going to do for me. You're going to go right here, Curvy Chick Vibes, and follow her, like her content. Yes, that's my wife. Yes, she's beautiful. Yes, she's brilliant. She's also a TikTok Shop affiliate. I ain't asking you to buy nothing. I want you to go there, like her content, and share it. Thank you very much. I'll wait. Grab your popcorn, folks. The emperor truly has no clothes. Are you ready for your freedom from government? Well, you're about to learn about a money-grabbing, society-controlling, governing for profit, unlawful scam that's been plaguing America for far too long. You'll never be the same after reading this, I guarantee it. The notice is found deep inside this article. You're going to need to listen and read the entire article in its entirety so you understand why and how to use this notice to hold a prosecutor accountable for his trespasses when filing false claims, criminal complaints into court against you. You are about to take the red pill, and believe me when I say that your attorney was not taught this information in law school, and I mean statute code school. If you share this with your attorney and he claims that it's a patriot, mythology, sovereign citizen horseshit that's never worked in court or has been proven to be free man on the land conspiracy nut job gobbledygook, unsubstantiated legal theories that have been proven false time and time again, etc., he's flat ass out lying to you. Pure spite, deceit, or even better yet, complete and utter ignorance of the law. There's a warning to all prosecutors who insist on bringing forth false claims, criminal complaints against your fellow man on behalf of your imaginary friends, such as the city of Galveston versus John Q. Public, unlawful possession of whatever, or the state of Texas versus John Q. Public for unlawful possession of whatever, or the United States versus John Q. Public, failure to file whatever, or any other government agency such as the DEA, the FBI, the IRS, BLM, etc. Here's how you're going to keep the IRS and the rest of those people out of your business, and I mean permanently out of your business. Tell them you better be able to cough up your imaginary friend, the plaintiff, to take the stand and verify his claims, or you're going to be one of the witnesses on the stand as a defendant in a trespass claim for filing false claims against your fellow man. The state of Texas versus John Q. Public, notice from hell. Update, as of October 2nd, 2018, this very notice that you will see further down in this article has made 83 cases vanish from PACER, better known of, without a trace. Gone, poof, never fucking happened, no paper trail, vanished into thin fucking air. There are actual screenshots from real people in the post this came out of that have verified the notice, made their cases vanish from PACER, and it's in the comment sections on the Facebook page. Don't leave a comment here asking me to prove to you that it works. There are people out there who use the notice. They've posted their results on Facebook and other platforms. As a matter of fact, this entire excerpt came from Facebook. You can go find the post. They've come forth several times over the last few years in defense of this to shut up the naysayers and the non-believers, but they're done airing their dirty laundry. The problem is this. One thing I always seem to notice is that anytime someone claims a remedy in law has actually worked, all the naysayers from Missouri show up, the show me state, and they want some kind of fucking proof. Screenshots in the comment sections of the Facebook post will provide you with your proof. No one is forcing you to use this notice. If you feel it may benefit you, then use it or don't. If the notice didn't work, I wouldn't waste my time with this article. I got more important things to do with my life, and I would not share something like this if it was a failure and had not been proven to work. So continuing about your attorney, try not to hold it against them. They weren't trained in actual law, such as the common law that this nation was founded upon and still operates under this day. He was, however, trained in codes and statutes, and there is a huge difference between actual law and statutory law that is being taught in law schools. Bar attorneys are prosecutors or defenders of people who are being compensated to abide by codes, rules, regulations, and statutes as found in the U.S. codes or state statutes. Those compensated people, I speak of, are government employees on either a local, state, or federal level. When you read a statute that says, no person shall possess a fully suppressed automatic weapon or firearm without first obtaining a Class 3 weapons permit, or no person shall openly carry a firearm without having first obtained a concealed carry permit, you must pay very, very close attention to the words being used. That nasty little word person doesn't mean what you think it means within their statutes. That word is actually code for federal employee, and federal employees are being compensated to abide by those restrictive firearm statutes and other statutes while they're on the clock receiving their government paycheck, but you and I are not. It is actually against the attorney's bar charter to represent anyone other than officers, employees, or elected officials of corporations, such as the corporation known as the United States, or one of its sub-corporations, such as the state of Texas, or one of its sub-corporations, such as the city of Galveston. But they do it anyway because the majority of the population doesn't know the law. If an attorney tells you that common law has been abolished, is no longer being utilized, is out of date, etc., ask him to show you the footnote under Article 7 of the Bill of Rights or the amendment to the Constitution that has abolished Article 7, the 7th Amendment. Believe me, America is still a common law nation, but your supposed government would rather that you believe it is a code land like France. Don't allow yourself to be fooled by this treacherous attempt to govern you and your family under statutory law, which only applies to government employees who are being compensated to abide by those codes and statutes found in U.S. codes and the state statutes. They have their laws, U.S. codes and state statutes, and we, the people, have our law, the common law, which is unwritten law, and here it is. Do no harm. As in, you can do anything you damn well please, and you may own, buy, sell, trade, anything you damn well please on American soil as long as you're not harming your fellow man or his property. Excuse me. If by doing any of those things you actually do harm to your fellow man or his property, you have now committed a trespass upon your fellow man. You will never see the words man or woman within their codes because government is instituted amongst men to protect and secure his rights and property, but government is not obligated to protect and secure the rights and property of persons or individuals, which are statutory words they have created within their codes to define their own internal employees, and they've also hoodwinked the average man or woman into believing that those codes actually apply to them. These people are master word nerds, and you need to believe it. Also, it must be noted that they have their Supreme Court, the Supreme Court of the United States, and we the people have our Supreme Court, your local county courthouse, which is superior to their Supreme Court. Your local county courthouse is superior to the Supreme Court as in this, that no fact tried by a jury in that court shall be otherwise re-examined in any court of the United States, and that it would include which court. Now wait. There he is in the back, you got it. The Supreme Court of the United States, which is the Supreme Court of government employees, not the average man or woman not holding a government job. Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Attorneys would have you believe the law is difficult, that you need years of special training to understand it, and that the law and how to protect and secure your rights, but the truth is, it's been overcomplicated. So let's begin. I want you to take a second and notice who the plaintiff is in the photo attached to this, okay? This photo has nothing to do with anything other than to show you what a criminal complaint looks like, where a claimant on the lower right-hand corner has brought forth a claim against a man on behalf of his imaginary friend that goes by the name United States of America. And the claimant is claiming this man, defendant, has harmed his imaginary friend, the United States of America, who is not a living man. However, it is the prosecutor's and the claimant's imaginary friend. So do you really think that some man named the United States of America or the United States or the state of Texas or the city of Galveston ran down and they hired this claimant to file a complaint on his behalf, who then hired an attorney to file a criminal complaint against you For a little side note here, that they don't like leaving behind paper trails for others to see. And once you've entered a notice like this into a prosecutor's case, he knows he's about to bear the full liability and be held accountable. And that is what makes cases disappear from PACER in a literal puff like magic. Okay? Anytime a prosecuting attorney is bringing charges against you for anything pertaining to a code or a statute violation, such as those found in U.S. codes and state statutes, he's operating under the presumption that you are one of the corporation's own internal employees who is contractually obligated to abide by those internal statutes. It's a con, and they make billions of dollars every year from unsuspecting Americans because we don't know the difference between a criminal complaint and an actual complaint. And all of this is explained in more detail here, and it will be well worth your time to go read this link right up here on the page. The Second Amendment isn't under attack. You've simply never been taught the difference between statutes and the actual law. It's a Facebook post. It's right there. Go read it. If you're not employed by that corporation, such as the IRS or the city of Galveston or the FBI or the BLM or the state of Texas or the United States, and being compensated to abide by that corporation's internal rules, codes, statutes, and regulations, they simply do not apply to you, as slavery and involuntary servitude are against the law on American soil. See Amendment 8, and no man may compel performance, force him to abide by internal corporate statutes, duties, and obligations from another man, without fairly and justly compensating that man for his performance. Employees have signed into an employment contract to hold those government jobs, and they are being compensated to abide by that corporation's internal statutes. But you and I are not. Therefore, they simply do not apply to us. Yes, it is a nationwide con that has been ongoing for years. It is how they control society under corporate statutes. It is how they interfere with your rights. It is how they make billions of dollars due to our ignorance of the law. And it is how they incarcerate us for victimless crimes where there is no injured party. Anytime a prosecutor brings forth a criminal complaint against you, it reads like this. State of Texas versus John Q. Public, illegal possession of cannabis oil, marijuana, automatic weapons, etc. If he had an actual claim, it would read like this. Bob T. Jones II versus John Q. Public. Bob is the prosecutor himself in his capacity as a man. He is filing a complaint on behalf of his imaginary friend that goes by the name State of Texas. But he has no verifiable claim because nothing you may have done harmed him or his personal property. And he cannot produce his plaintiff, his imaginary friend, to point you out across the courtroom and say, that guy sitting right over there, that's the one that caused me harm by his failure to file an income tax return, or his failure to obtain a concealed carry permit, or his possession of cannabis, oil, etc. Yeah. You have the right to face your accuser, Amendment 6, to cross-examine him and to avoid any cases of mistaken identity. That is why you must require the prosecutor to cough up his imaginary friend to take the stand and verify his claims against you with his mouth in open court, pressing it upon the court with his voice, and only a living, breathing man can do that. The other reason you want the prosecutor to cough up his imaginary friend is to verify his claims against you. If so, you'll never know exactly who to hold accountable should those claims turn out to be false or inaccurate, right? You want to know who's bearing liability for this matter should he be lying, and who you can file your own claim against should he be acting in dishonor by dragging you into court and wasting your time with a complaint that no living man can take the stand and verify, that could have possibly landed you in prison on that very day. Someone, a living man, has to bear liability should the claims turn out to be false and inaccurate. That someone's name needs to be the actual plaintiff, not an imaginary entity you'll never be able to track down and hold accountable for his trespasses. A prosecutor can certify his piece of shit, worthless, toothless complaint because he's the one who wrote that piece of shit. A notary can certify she's seen a piece of paper, but can she verify anything on that piece of paper is actually true? Not unless she herself has personal firsthand knowledge. You don't care about his certified complaint. You want to see a verifiable claim so you know who's asked to nail to the cross when that claim turns out to be false, and is nothing more than an attempt to maliciously prosecute you to unjustly enrich himself and his imaginary friends. Remember, he's only complaining because the government can't bring forth actual claims against a man because man created government. All they can do is complain. If you are not an employee of that agency who's being compensated to abide by that agency's internal corporate codes and statutes, but his complaints are causing you harm. They're harming your good name within your community. They're depriving you of your property without due process of law. And they're wasting your very valuable time, money, and resources having to deal with a complaint that no one can take the stand and verify in open court. Therefore, the prosecutor is filing false claims against his fellow man, and that is an unlawful act in which he most certainly can be held accountable. If the prosecutor has a problem with you, then he needs to bring forth the claim on his own behalf, him as the actual plaintiff, not on behalf of his imaginary friend that's nowhere in sight. Someone has to bear all liability should the claims turn out to be false, and good luck tracking down his imaginary friend who can't even fog up a fucking mirror. To use this notice in an existing case, you're just going to replace State of Texas with IRS, City of Galveston, or Child Protective Services, or United States, etc., depending on whatever's going on with you. Yes, any of them, whatever's going on with you. If there is no property involved and it's just some prosecutor attempting to bring you up on criminal complaint for something, anything, just take out the parts having to do with property. Handwrite the notice. Let me say that again. Handwrite the notice on paper with pen. Why? Because you are living, breathing. Make copies of the notice. You'll want to enter a copy into the prosecutor's case, not the original, as doing so would be surrendering your property to the court. You want to keep that original so that they cannot alter it in any way, shape, or form. The only body that may hold and verify the original would be a jury of your peers. You must be very vigilant in protecting your property, claims, and notices when dealing with these courts and prosecutors, okay? If they can change or alter it in any way, change your claim into a complaint, something like that, to get themselves off the hook, you better bet your fucking ass they're going to do it. Protect yourself and only enter a copy into the case so they know you still possess the original. They decide to trespass on your property by altering it in any way, shape, or form. Court clerks are notorious for changing claims into complaints without your knowledge, so stay vigilant. Remember, America is still a common law nation, as is Canada, England, Australia, and a few others. Common law is unwritten law. It is nowhere to be found in codes, statutes, rules, regulations. Basically, you can do anything you damn well please, as long as you're not harming your fellow man or his property, and you have the right to face your accuser, see Article 6, and settle with him on the private side before it goes public, if for some reason you do trespass on your fellow woman or man, right? Beware of the bar shysters who say that the Sixth Amendment only guarantees you the right to confront the witnesses against you. It says nothing about your accuser. Here's where the common sense comes into play. Would an accuser have not also witnessed the supposed crime? In more detail right here at this link, right here on Facebook as well, okay? Use your noggin, guys. Therefore, if the prosecutor is stating the IRS or the state of Idaho, etc., is the plaintiff, then make that son of a bitch put his plaintiff on the witness stand so you may cross-examine him and compensate him for any harm you may have caused him on his personal property by your failure to file paperwork such as tax forms, or failure to obtain a concealed carry permit, or failure to obtain a Class 3 weapons tax stamp, or possession of marijuana, or what the fuck ever. If he can't produce the plaintiff must appear, then sue his ass for filing false claims against you and take his house or his retirement fund. Someone, a living woman or man, has to show up and verify the harm, injury, or loss. Are you ready? Here's the notice. And yes, capitalization and punctuation mean everything. Pay attention to exactly what it says. Write it out exactly as it is. Don't change anything because you're smart and you think you're crafty and you know you need to add something that needs to be in there. It works. KISS. Keep it simple, stupid. Here we go. Notice, I, a man, require the state of Texas, whomever, to show up in court, take the stand, present me with photo ID, a driver's license with his/her name, state of Texas, clearly printed on it, a current street address, and a clear photo of his/her face to enter into the record, so I'll know who to hold personally liable should the claims against me turn out to be false and or inaccurate. and verify her claim against me so I may cross-examine my accuser. Amendment 6, the accuser surely witnessed the supposed crime, and the plaintiff must appear, and compensate her for any harm, injury, or loss I may have caused. If this woman that goes by the name State of Texas cannot show up to verify her claim, I require this matter immediately discharged, as the court will have no jurisdiction to even hear the case, because there is apparently no controversy before this court. It is my belief there is no woman named State of Texas who can verify this claim by pointing me out across the room and uttering with his or her voice, "I've done wrong or caused her personal harm, injury, or loss," therefore pressing it upon the record in open court, as I've never even heard of this woman and don't believe we've ever crossed paths, to be quite honest. It is also my belief that someone is filing frivolous complaints, false claims, on behalf of their imaginary friend known as the State of Texas, in an attempt to unjustly enrich themselves and the State of Texas, whoever those individuals may be, in an attempt to deprive me of my rights, liberty, and property without due process of law and or fair and just compensation. If this matter is not immediately discharged prior to the first hearing, I will be requiring leave of court so I may bring forth an actual proper and verifiable claim before the court to address these trespasses against me in the proper venue, a court of record. Trespasses being filing false claims, barratry, extortion, malicious prosecution, unjust enrichment, fraud, theft, robbery, kidnapping, etc., in which I will be requiring compensation for the trespasses, as well as compensation for wasting my valuable time, money, and resources. Having to deal with this complaint, no living man can take the stand and verify, as I do not have time to answer complaints without compensation at this time. Unless there is a verified claim before this court and not a verified complaint, I will require compensation and provide a bill to whoever is responsible for me having to take time off work to listen to the complaints. I charge $25,752.83 in U.S. dollars, Federal Reserve notes, and or gold, silver coin to show up and listen to complaints, and an additional $1,047.60 per minute I am standing there. Balance due within 30 days of hearing. Failure to discharge this complaint is agreeance to these terms and conditions. You have disrupted my life having to deal with this complaint you have filed on behalf of your imaginary friend, and I simply want to get on with my life. I'm willing to forgive this trespass should you decide to act in honor and discharge this matter immediately. In the unforeseen event I have been unlawfully incarcerated due to this criminal complaint or warrant issued due to this criminal complaint, false claim, I will also be requiring compensation of $1,500 per minute for every minute I have been or am incarcerated, from the very commencement of the crime till I be released. If there is an actual verifiable claim before the court, I will be more than happy to show up free of charge and address any proper and verifiable claim against me and compensate any man I have caused harm, injury, or loss. I also require and order the immediate restoration of my property, see Exhibit A, and $1 per second from the commencement of the crime till my property be restored. Your name here. Note 1, to those of you who are new to common law, as well as you legal experts, you might want to read my comments below, especially the ones about the temptation to razzle and dazzle everyone with your legalese bullshit by adding codes, statutes, and case law of any kind to that notice to give it more teeth because you think it's too simple and needs more crap added to it. Note 2, if there is no theft, robbery of property, or kidnapping involved, just leave that out of the notice. Property is anything you enjoy exclusive rights to. If it's CPS case involving your children, you use the word property, not children. The state has no control over your property, but they do have control over other words that they use in their statutes like child, infant, children, motor vehicle, marijuana, automatic weapon, firearms, land, homes, bicycles, etc. You always use the word property, period. And Exhibit A should be a photo of the property attached to the back of your notice. A photocopy of that property is fine. Pricing for trespasses may be different than listed. If you feel that's not enough or too much, change your invoice to reflect your required compensation. His wife Nora required the immediate restoration of her property, a child, and threatened to charge the state $1 per second for every second her property was not restored, and the judge ordered the immediate restoration of the property. Once you claim your property and no one can show up to court and verify a superior claim to that property, then the judge has to order the restoration of the property, or he himself now becomes an accessory to the theft, robbery, or crime after the fact. And now you can file a claim against him or her for that trespass. Bonus note, the government hates it when you use the pesky word property in your claims because the government has no control over the property of man, but it does have control over the words they've created within their own statutes, such as child or firearms or automobiles or whatever. You let them call it whatever they want to call it. You call it property. In the end, it's property. There's a good place right here, this link right here, to begin your journey on property. Back to the steak and potatoes. Either someone can show up and verify the claim by pressing it upon the record in open court, or there is no case, period. The prosecutor cannot verify the claim because he has no firsthand knowledge, and nothing you may have done has caused him harm, injury, or loss, not to himself or his personal property. And his imaginary friend cannot speak, can't even fog up a mirror, and we all know by now that the plaintiff must do what? They must appear and verify his/her claims so that there is someone who can bear full liability should those claims turn out to be false or inaccurate. If the prosecutor has a problem with you, the prosecutor needs to enter his personal name and is the plaintiff in the lawsuit, not his imaginary friend who you'll never be able to run down once you start filing your claims. Simply put, he's filing false claims against you to unjustly enrich himself, put you in a cage so they can rape your birth bond and fill their industrial prison complex with fresh souls for more state federal funding. And this entity known as the state of Texas or the IRS or the United States or whoever it is, you're letting the man, woman who's prosecuting this case against you know that if they don't discharge this nonsense before the next hearing, you're going to stop the next hearing in its tracks by saying, I require leave of court so I may bring forth a proper and verifiable claim against you for filing false claims against me. And I will be requiring compensation for the trespasses, and that compensation is not going to be cheap. And if a jury sees it, it may be you who ends up in prison for trespasses instead of me. You see, up to this point, the prosecutor had no skin in the game. If he wins or loses, he suffers no loss other than his time. But when you bring forth your own claim in your court against him, now he definitely has some skin in the game, and now he may very well lose a lot of money and or get sentenced to prison himself for trespasses against his fellow man. Filing false claims is very serious business. Those clowns ruin a lot of people's lives with their con and filing criminal complaints into courthouses that no living man can verify. But up until now, we haven't known how to hold them personally accountable for their trespasses, which makes the game a whole lot more interesting. Wouldn't you agree? Now that you have two players who may be held accountable instead of only one, just you, right? Now you have some kind of actual skin in the game, which is exactly how it should be. If anyone else went down their local county courthouse and started filing bullshit complaints in the court on behalf of their imaginary friend, they'd be locked up. Filing claims is serious business, and filing false claims is real serious fucking business. Remember, your claim supersedes his silly complaint. You can verify your claim, but he cannot verify the complaint. And court is no place for men to waste the court's time and resources listening to men complain about other men. The prosecutor himself has no firsthand knowledge of anything unless he is the actual injured party bringing the suit. And nothing you may have done caused harm, injury, or loss to himself or his property, and he cannot produce his plaintiff because there is no man named the state of Texas who can take the stand and verify the complaint either. Court is a place for man to settle his claims, not his complaints. This is why so many police brutality cases get dismissed and people don't get the remedy that they rightfully deserve because they're filing complaints with the cops department instead of filing an actual claim against the cop for his trespasses, harassing you, assaulting you, kidnapping you, killing your pet, beating the shit out of you because you didn't respect their authority, and dragging his ass in his private personal capacity as a man into court for his trespasses. Just because he has a badge does not give him the right to harm another man. And I was just doing my job ain't gonna fucking cut it. You do not want to file a complaint with his department because no one wants to listen to you complain. They will, on the other hand, listen when you file an actual claim, and there is a huge difference between the two. They call it a criminal complaint for a reason. It is nothing more than a prosecutor complaining about your personal possessions or something you might have done. He has no verifiable claim, therefore He has no verifiable claim, therefore all he can do is complain, hence criminal complaint. Back to the story. You'll want to enter that notice into any existing case they have against you. If the prosecutor doesn't dismiss the case after reading that notice, he's just calling your bluff. When you get to the hearing, simply keep your mouth shut and keep referring to the judge back to the notice anytime he asks you questions, because he is trying to pull you out of the common law and back into their statutory jurisdiction or under his control. If he asks you a question, have him write that question on a piece of paper. Now you've dragged him out of his fiction and into his capacity as a man that is dealing with another man, answering the question in writing if you can, or require leave of court to prepare your answer. But always keep your mouth shut as much as possible and keep referring him back to the notice so he can't trick you into saying something that drags you back under his jurisdiction. If they insist on continuing or ignoring you, then do what you said you'd do in the notice and demand it by authority immediately, leave of court for a few days so you can perfect your actual claim against the prosecutor and drag his ass into your court as a defendant for filing claims against you at the next hearing after they listen to his complaint in his court. Because the compensation you'll be requiring for the trespass shall exceed $20, you'll be able to drag him into a trial by jury, see Article 7, as a defendant for filing false claims against you that no plaintiff showed up to verify. And here's how you file an actual claim that runs concurrent with his complaint and enter a notice claim trespass into his existing case to be heard at the next upcoming hearing. There's the link. The courthouse is a public building where all men may file claims to settle their disputes with another man. The Bar Association spends a lot of time in that public building, right? That belongs to us, the public, prosecuting people, you and me, for statutory violations in the prosecutor's court. When he brings forth a complaint to that public building, he is bringing his court to that public building. When you bring your claim to that public building, you are bringing your court to that public building. Your court is a court of record and under common law, in which now you are the prosecutor. The jury is now the judge, and the man usually acting as a judge is now lowered to the status of a referee to keep court decorum, to sign the orders of the judge, the jury, and he can no longer tell you to sit down and shut up in your court because he is a guest. You have required his services to help you settle a claim against another man. If he's not qualified, find another judge who is qualified to act in that capacity at common law in a court of record as an Article 3 judge who is there to help protect and secure your rights versus operating in his capacity as an administrative judge, administrating one of their 14th Amendment citizens of the United States, aka federal employee presumption of a legal, lawful person. This is why there's a judge on duty 24/7 at all courthouses for emergency hearings when there is an emergency dispute that needs to be settled, such as a kidnapping or a theft or a robbery of a child by CPS. We pay them and the clerks and the janitors and the window cleaners and everybody else to keep that public courthouse up to par for us and a magistrate on duty 24/7, 365 in case we have a dispute to settle with another man. They don't own the courthouse. They'd like you to think otherwise. The people own that public building, and the Bar Association rents it just like we do by paying court fees just like we do. If a prosecutor is claiming the United States is the plaintiff in his suit against you, then for the love of God, make him produce his plaintiff so you may cross-examine your accuser. Article 6 guarantees you that right. That right predates the Constitution. He can't produce the plaintiff because the United States is not a living man who can utter with his voice you've done wrong and caused him personal harm, injury, or loss. And this is how you call them out on it and hold them personally accountable for filing false claims against you. In order for there to be a controversy for the judge to hear, there must be a living man or woman willing to take the stand and verify harm, injury, or loss you may have caused. If no living man or woman can take the stand, then there is no controversy, and what the hell are we doing here? If there is no woman willing to take the stand and verify that you have caused them or their property harm, injury, or loss, then there is no controversy. If there is no controversy, there is no jurisdiction of any court and any judge to ever entertain the case because there is no case. This is why it may not be in your best interest to hire an attorney to represent you, because by doing so, you have surrendered to an officer of the court and can no longer make any jurisdictional challenges. Corpus juris secundum. A corporation such as the United States or the state of Texas cannot take the stand. It's fictitious corporate entity created by man. It does not speak, it does not eat, it doesn't drink, it cannot bring forth a claim against a living man. Therefore, there is no one to verify the claim. Now, if you'd like to learn real and actual law of this land and how to defend yourself against government agents, here's a great place to start. Carl Lentz. I know it was a long one. I know it was full of stuff you probably don't understand. Watch it again, read the whole thing, listen to the whole thing again, write it down, pause the screen, take a screenshot so you can get it all there, copy that notice word for word exactly as it's written. Let's go, guys.